In this second episode of CALS Chai Chats, Mario and I will continue to unpack the relationship between law and social cohesion from the perspective of judging and the role of the courts. So joining us today is Justice Yasantha Kodagoda from the Supreme Court of Sri Lanka. Welcome, Justice Kodagoda, and thank you for being here today. We are extremely honored to have you as our guest in this podcast.
It's my pleasure to join you at this program.
Justice Kodagoda has had a unique legal career, combining legal practice with the service on the bench. He started his career as a state counsel with the Attorney General's Department in Sri Lanka. He has prosecuted in criminal courts, worked in the areas of commercial law, forensic science, and human rights, appeared before UN bodies, including the UN Human Rights Council and the former Commission on Human Rights, and has been the lead counsel for several commissions of inquiry in Sri Lanka. In 2019, he was appointed as the president of the Court of Appeal in Sri Lanka, the second highest appellate court, and in 2020 was appointed to the Supreme Court of Sri Lanka, where he continues to serve. Thank you again, Justice Kodagoda, for joining us. Just to start this conversation, I was wondering, for the benefit of our listeners and our audience, whether you could reflect on the evolution of Sri Lankan society during your career, both as a lawyer and as a judge.
I think over a period of time, Sri Lankan society, as well as its constituent members like Mario and myself, we've all gone through a process of evolution. And significant environmental factors such as the economic situation of the country, the political environment of the country, the security environment of the country, as well as the ever-evolving socio-cultural dynamics of the country have contributed towards the society itself evolving, as well as our own thought processes and conduct. We are mere passengers of an evolving environment. And I think periods of turmoil, such as the period in which the ethnic conflict assumed the manifestation of terrorism and an ensuing armed conflict, had significant impact on us as a society. And the inevitable outcome of such social lesions has resulted in a considerable polarization of our society, which has had its own adverse impacts on social cohesion.
I like you mentioned, Justice Kodagoda, about how we're all passengers in an evolving society. And we know that Sri Lanka is incredibly diverse socially, politically, and economically. You mentioned certain issues that have emerged out of such diversity in your explanation just now. In your opinion, why have such issues emerged, and do they reflect any underlying tensions in the society?
Yes, but also I would think such social lesions are inevitable. It happens globally from country to another. And I don't think Sri Lanka necessarily serves as an alarming exception. Polarization of society in multiple dimensions occur and is prevalent world over, with Sri Lanka not being an exception. However, possibly the very nature of the content of Sri Lankan society, multiple ethnicities, multiple languages being spoken, cultural orientations being different, multiple political ideologies that has penetrated different layers of society, difference in economic and financial stability. So all of those factors, I think, has contributed towards lack, and I don't think necessarily absence, but lack of social cohesion.
That's really interesting, Justice Kodagoda. So with reflecting on these issues that you have raised, what sorts of cases that have come before the courts, if any, during your tenure, or any issues in general that you have found most challenging to deal with, especially in your experience as a judge?
Well, I must preface my answer by saying that though I sit on the Supreme Court bench, my judicial experience has been quite limited. From a duration perspective, limited to 3 years. So what I have to say has to be seen in view of that caveat. We see lack of social cohesion in a lot of cases we are called upon to hear in the Supreme Court, particularly cases involving allegations of breach of fundamental rights, cases where public law doctrines have to be applied, are instances where you see lack of social cohesion, multiple forms of tensions in society. So we see it often as opposed to seldom, I would think.
Thank you, Justice Kodagoda, for that. I just want to ask you, do you think judges should be involved in navigating these complex issues? And if so, how do they sort of navigate competing tensions in Sri Lankan society?
I would, my very brief answer, Mario, to the first question is in the affirmative. Yes, I think we have, as judges, that wider role towards curing, if I may use that term, curing society. However, that duty, I would think, should necessarily be performed in terms of the jurisdiction that has been vested in us. Our jurisdiction is unique. Judicial power originally lies with the people who are sovereign, and they have chosen to channel the judicial component of their sovereignty through, of course, the constitution, and thereafter the parliament finally vesting it in the judiciary. So I think it is important to be mindful of that limitation. We don't have a plenary form of unrestricted judicial power. Our power derives from the sovereignty of the people, channeled to us through the constitution and parliament. And how has parliament vested jurisdiction in us? Through written law, through acts of parliament. So we need to be mindful of what that arrangement entails, considerable limitations. And particularly in a country like Sri Lanka, where a very large realm of law, in its plural sense, has been codified by parliament, by successive parliaments, we need to necessarily recognize and enforce the law, the written law, when adjudicating disputes. Fortunately, there is still a considerable volume of law left in the realm of unwritten law, may it be public law, multiple spheres of private law, commercial law, etc. There is still, particularly in view of the colonial heritage that we have inherited, we have a considerable volume of law in the spectrum of unwritten law, which you might also refer to as multiple manifestations of common law. Now, it is the unwritten law that can be mobilized by judges to engage in considerable amount of innovative outcomes. Uh, it is common law that helps you to not only interpret the law, but also adapt the law to suit contemporary situations we have to grapple with. And I think that is how the law can be mobilized by judges to cure multiple ailments in society. And of course, contribute towards the strengthening of the rule of law, including fundamental rights, and also facilitating the development of social cohesion.
That's a fascinating sort of take and response, I think. I wonder whether I could just, push you a little more on this idea of unwritten law, um, and to ask you whether, in the realm of unwritten law, are there particular concepts or doctrines or ideas that you think may be useful in helping judges navigate these complex issues of social cohesion?
I would think I can think of multiple concepts of law and doctrines in unwritten law, in the common law, that can be used in this regard. And I think the starting point is the plural dimensions of the concept of equality and the wider notions of justice. I think that is the starting point. Problems with regard to social cohesion fundamentally arise due to either lack or absence of equality. If there is equality in its wider sense, if everybody can enjoy fundamental rights and freedoms, if rule of law were to reign supreme in society, I think social cohesion, peace and tranquility, including peaceful coexistence among multiple communities, would be the natural and the inevitable outcome. So, in that regard, yes, indeed, we as judges have a very important role to play in ensuring that rule of law reigns supreme, that the supremacy of constitutionalism is only second to the supremacy of the people, um, and that those virtuous values found in common law are recognized and enforced. And how do we do that? We do that by using those doctrines, including the doctrine of fairness and proportionality, in the interpretation of the law, in filling lacuna in the law, and where required, in adapting somewhat conservative principles of law to cater to contemporary requirements of society.
On a slightly different note, I'm just wondering whether judges see some of these complex issues as opportunities. So, not only as a means of resolving complex issues in society and providing adjudication and a resolution of that, but in their judicial mind, or as a litigator when you appeared before judges, did you feel that judges also see it as an opportunity, perhaps, to shape society in a particular way, in a way that is harmonious, and to try and reduce some of the tensions and divisions in society?
It Well, Mario, I think it depends to some extent on individual philosophy of judges. You get judges and judges, and when I say there are judges and judges, I don't for a moment mean that one group of judges are better than the other group. We all are human beings. We have our individual philosophies. We then have an additional layer of judicial philosophies. And those judicial philosophies, I think, can differ from a judge to another, though we have to necessarily respect and abide by the three golden principles of being a judge, namely independence, impartiality, and neutrality, there are naturally tensions that crop up in our mind, which can easily take us away from that virtuous requirement of being neutral. Our personal philosophies, beliefs, and values competing with the requirements of written law. So it can give rise to considerable tension. So yes, there can be a vast difference in how one judge were to approach a issue as opposed to how another judge would approach the same issue. You might get one judge who truly believes and sincerely believes that his role is to merely adjudicate by applying the law to the given case, resulting in a determination of the dispute in terms of the law. Yes, and there will be a winner and a loser. There will be another judge who would think, oh my God, I must do much more than deciding this case. I must make use of this opportunity to resolve wider issues, including causing a development of the law and ensuring that the judgment results in long-term development in society. So it's I don't think one approach is any better or bad than the other. It's up to individual judges.
Your reflections, Justice Kodagoda, I find it really rich, what you have said for the past 5 or 10 minutes or so. And I think you sit in a very, very interesting position, Justice Kodagoda, by virtue of your professional background. You have this benefit of experiencing both sides of adjudication and litigation, so to speak. So let's turn to the Sri Lankan constitution more specifically. You talked about the constitution earlier, about equality, fundamental rights. The right to equality and equal protection of the law has been invoked by the Sri Lankan Supreme Court on many occasions to resolve a variety of different cases that have an impact directly or indirectly on social cohesion. What are your thoughts, Justice Kodagoda, on this approach of invoking the right to equality and equal protection of the law? Has it worked well? If so, why? If not, why not?
Well, I think the starting point was Sri Lankan judiciary's interpretation of that particular provision of the constitution, commonly referred to as Article 12. During the first maybe 5 years or so, since 1978, when the Second Republican Constitution came into being, that article was seen as merely an instrument to remedy discrimination. But fortunately, subsequent judges assumed and conferred on that article, justifiably, I would think, a wider meaning so as to encapsulate equality and the wider doctrine of the rule of law. So it is now, Article 12 is now seen as the single most important fundamental right that protects individuals as well as groups from any form of discrimination or infringement of the rule of law. I don't think it would take long for the Supreme Court of Sri Lanka to recognize that embedded in the equality clause is the due process of law as well. Because as you would appreciate, there is only a very, very thin and a blur line that separates the doctrine of the rule of law from the doctrine of the due process of the law. So possibly it is already within our law. Now, having said that, this is used to remedy multiple maladies in society, particularly those stemming from abuse of law by the state and its agents. We do this day in, day out. Uh, Various allegations of infringement of fundamental rights. It is the equality clause that is used to provide relief, to declare that there has been a violation of the law, and also to provide relief because uh, the jurisdiction of fundamental rights enables the Supreme Court to exercise a very wide jurisdiction and grant any form of relief that would be just and equitable in the circumstances of the case. Any form of dispute arising out of state action can be addressed using the equality clause. And I think that is extremely important so as to ensure that we create a conducive environment in society that will enable a growth in social cohesion.
Would you like to elaborate, Justice Kodagoda, on any specific cases, more specific concrete cases with respect to this use of equality to pursue certain claims as against the state and with an impact on social cohesion?
Oh my God, multiple. Maybe the exercise of religious freedom, uh, issues pertaining to access to state resources and services, such as free education. I would think there would be maybe a dozen of cases where relief is sought by invoking the equality clause or Article 12. Um, so many, and uh, this wide interpretation given to equal protection of the law slash equality has has enabled the court to engage in a degree of cross-fertilization of jurisprudence between the fundamental rights jurisdiction and the writ jurisdiction, which is the more common form of jurisdiction that is invoked by court uh, to cause judicial review of executive and administrative action.
That's very interesting. And I think perhaps at some point Mario will want to weigh in on that because of this cross-fertilization between writs and rights is his pet topic. But just to get you to reflect a little more, Justice Kodagoda, on transnational and international developments. Transnational and international developments, including those on human rights and principles on constitutionalism, rule of law, do these inform judicial decision making in Sri Lanka?
Very briefly speaking, I would think yes, but in a very indirect manner. Uh, I had the occasion to represent the state and advocate before the Supreme Court in my previous capacity as a law officer of the state, that the relationship between international law at large and the municipal law, the domestic national law, is dualist in nature, as opposed to being monist. This judgment, I'm conscious, has been highly criticized by human rights advocates in particular. Be that as it may, I still to date sincerely believe that the relationship is dualist in nature. Be that as it may, once a nation state subscribes to international law, I think it is the responsibility of the state to act in terms of their respective constitution and indoctrinate those norms and standards found in international law into its municipal legislation. Now, unfortunately, uh, there are states that have not fulfilled that component of their responsibility of incorporating into municipal legislation international law that they have subscribed to. So, in other words, they go out to the international arena, they subscribe to uh, international law, but they come back and fail to enact what we would refer to as enabling legislation. Now, this leaves a considerable gap or a lacuna. Uh, you have international law. The judge is conscious that the state has subscribed to that international law, but has failed to fulfill its duty of enacting enabling legislation. So it's not part of municipal law in the backdrop of the relationship between international law and municipal law being dualist. And then what does the judge do? One approach to be taken, a very conservative approach, which I would not recommend, is to say that the municipal law does not contain that particular norm or standard found in international law and refuse to apply it locally. That's one approach. And I would not necessarily subscribe to that approach. The other more liberal and innovative approach would be to use international law doctrines when interpreting municipal law. When interpreting municipal law, and if the law itself permits, when engaging in adaptations and modifications of the municipal law. Now, if in instances where that is possible, that is the devious route international law can take to come in to municipal law. That would, of course, require very delicate handling and considerable innovative skills on the part of judges.
Those are very interesting thoughts on the relationship between international law and domestic law. I just have a more specific question on the role and the value of comparative jurisprudence. And here I'm referring to jurisprudence from, it could be a common law jurisdiction or it could be a civil law jurisdiction. What sort of relevance do these judgments from other countries have in sort of developing our own public law jurisprudence? And do you see the Sri Lankan Court of Appeal and the Sri Lankan Supreme Court relying a lot on comparative approaches in developing Sri Lankan law? Is it at all useful?
Certainly, yes. I mean, if you look at the growth of administrative law and fundamental rights law in Sri Lanka, it has been primarily due to judicial borrowings, if I can use that term, from the United Kingdom and from neighboring India. I mean, that's the ground reality. If you just survey the development of administrative law and fundamental rights law, as well as constitutional law at large, we have been considerably influenced by our colleagues in the United Kingdom and in India. But having said that, I cannot see the Sri Lankan courts being obliged to follow foreign judicial products because of the fact that this has an impact on sovereignty. So, from the perspective of sovereignty, certainly the judgments of superior courts of other jurisdictions, of other countries, would not have any binding effect at all. But certainly, it would have a degree of persuasive effect, particularly if the judgment is founded upon law that is parallel to the law of Sri Lanka and arises out of parallel socio-political and cultural dynamics. And that is why we can often conveniently relate to Indian judgments because of the similarities found in our two countries. And we see this happening day in, day out in our courts. Judgments of, if I were to mention names, Justice Bhagwati, Justice Chandrachud, are often referred to in fundamental rights cases and in other cases involving public law. And I think it has certainly contributed towards the development of our national law and has enriched our thinking as well.
Thank you, Justice Kodagoda. I just wanted to ask you a question on the impact that public opinion has on judicial decision making. Does sort of public opinion sort of lurk in the background of a judicial mind, especially when judges decide cases that have consequences for social cohesion or important public interest consequences?
If I were to say that we keep aside everything else that we know and are sensitive of when we go on bench, I think I'm not being truthful. I think we carry a considerable amount of baggage onto the bench. These factors, including what we perceive to be public opinion, looms at large in our mind when we draft judgments, when we reflect on contemporary happenings. We try our level best to insulate ourselves from such external influences and to be as objective as possible when deciding co-issues in any given case. It is that objectivity in decision making that is most important. But I would think that intentionally or otherwise, we do have in the back of our mind external factors, including our understanding of public opinion. And particularly when we are called upon to exercise discretionary jurisdiction, I would think our understanding and perceptions of such external factors, very generic type of external factors, would have a bearing on decision making. But what reigns supreme and what must necessarily reign supreme is none of that, and that being the rule of law.
Thank you, Justice Kodagoda. I wonder whether, very briefly, I could ask you to reflect on something that emerged in a previous conversation we had with a former Indian Supreme Court judge. When he was talking about social cohesion cases, he spoke about a partnership between the bench and the bar, that these were not necessarily sort of confrontational processes, but that when you were dealing with issues of social division and public interests in society, you had to see this role as one of partnership between the sort of bench and the bar, and perhaps even civil society who might be involved as petitioners. I wonder whether you have any thoughts on that.
Certainly, in the sphere of public interest litigation, I think there is a compelling need to adopt that approach. And in that regard, I think officers of the Attorney General's Department have a very important, proactive, and a crucial role to play. Instead of seeking to protect the narrow interests of the state and its officers, certainly in public interest litigation, and even in other public law cases, I think officers of the Attorney General's Department must necessarily bear in mind that their foremost duty is to protect public interest, particularly in instances where there might be a gap between what amounts to public interest vis-a-vis the interest of the government and the relevant public officials. Um, and adopting this non-confrontational, uh, consultative type of approach in public interest litigation, I think really helps. A cooperative approach by the two sides in the case and the bench. But I think culturally, we stem from this common law, purely adversarial environment. And it is, I think, somewhat challenging to change gear in only this type of case. We are often used to, we as judges are often used to being umpires, allowing the two litigators to fight it out. And we come in at the end to determine the dispute in terms of what we believe and understand to be the law. This type of changing gear and attitude, I think, is very challenging. But I do take that point. Certainly, in cases that are aimed at curing social lesions, ensuring the development of social cohesion, um, and overall protection of the rule of law, I think there is a need to adopt a more cooperative approach in cases that will require a lot of change, I think, in the adjudicatory environment in the country.
If I could just chime in, since we're on that issue before we move on. I find your thoughts, Justice Kodagoda, on this cooperation issue really fascinating because both here and in Singapore, as well as abroad, there's a lot of this conversation about red light or green light approach to judicial review. And under the green light approach, the court or the judiciary has this role to set out clear rules and principles to guide the decision making of authorities. And in doing so, as you said, strengthens the rule of law.
Indeed. So it's more to do with how we approach dispute resolution through adjudication. We need to maybe recognize the fact that particularly in public law issues, in public interest litigation in particular, there is a need at times for the court to deviate from the classical style of adjudication to the adoption of a conciliatory approach, which necessitates cooperation from the two or multiple sides. And in this regard, I must also mention the need for reform, at least from a Sri Lankan perspective. Now, if you're to ensure that the outcomes of the judgment are fully realized by society and by the state, there is a need for some degree of oversight post-pronouncement of the judgment. Now, classically, Sri Lankan courts become functus with the delivery of the judgment. And we don't get involved in overseeing the enforcement and compliance with the judgment. There has been a few instances, 2 or 3 instances where the court has remained alive post-pronouncement of the judgment. I don't necessarily see those instances, though engaged in good faith by the respective judges, as being compliant with the rules of the court or the mandate of jurisdiction. Be that as it may, in India, you see how the Supreme Court of India appoints court commissioners to oversee compliance with the judgment and comprehensive enforcement of the dictates contained in the judgment. So maybe at some point of time, Sri Lanka must also necessarily look at the possible need to confer that additional role on the superior courts of this country.
Thank you. That's a very interesting perspective. It's been a very rich discussion so far, and as we come to the end of it, I just wanted to ask you a little bit to reflect on the court's jurisdiction to review proposed legislation. So the Supreme Court of Sri Lanka does not have the power of judicial review of legislation, but it does engage in what's called pre-enactment review of bills. Do you see a difference in approach in the way the court approaches a review of a bill as against reviewing sort of executive and administrative action ex post facto?
If your question is as to whether the opportunity the Supreme Court has to review intended legislation is sufficient, my answer would be a direct no. I think we, in the sense, not only the Supreme Court, but the people at large need a greater opportunity to look at constitutionality of intended laws which take the form of bills. We need a greater opportunity, particularly from a temporal perspective. I think it is necessary. Ideally, the public should be involved in contributing their views towards the formulation of the policy and the legal framework that will give birth to a bill. Now, having said that, I also think that it is necessary to confer jurisdiction on the Supreme Court to cause judicial review post-enactment. Of course, that opportunity cannot go on and on. There must be a post-enactment limited window of opportunity, maybe a year or 2 or 3, and certainly not more than that, from the first attempt at enforcing the provision of a new law, enforcing the provisions of a new law for aggrieved parties to challenge the constitutionality of the recently enacted law. So post-enactment judicial review, subject to that caveat of only a limited time period being given, I think is in national and public interest.
Thank you very much, Justice Kodagoda, for sharing with us your views, providing us with a really rich insider's perspective on the judicial role, the judicial philosophy, and the whole overarching issue of judging and social cohesion.
My pleasure, Dan, and it was my pleasure to participate in this discussion. Thank you very much for having invited me, Mario. All the best to both of you.
Thank you very much again.